Uh, at the end of the presentation, I will stay on the call and you can unmute yourself and ask for questions if you have any. And of course, obviously, you can always call me later this afternoon or email me and we'll try to answer any questions you don't want to talk about around everybody. In any event, like I say, I will mention a couple of things. We are keeping track of the people who are joining our call, but of course, sometimes we only get a phone number or an email, or if you're watching on your spouse's computer or something along those lines, we're not sure it's you. If you have a situation where you need to take this training due to the recent executive order or for other reasons, and you want to make sure that we know that you attended, you can always hit us with an email just saying, I'm making double sure that you know I attended, and we can keep record of that. Okay, let us begin. First off, I want to go over the topics for today, basically. First off, we'll be talking about what the West Virginia Ethics Commission handles. Then we're going to do a survey of the West Virginia Ethics Act, and then a survey of the Open Meetings Act. And like I say, at the very end, we'll have a question and answer period. First off, what does the West Virginia Ethics Commission handle? Obviously, we give advice and also take complaints for violations of the West Virginia Ethics Act. We also are given the authority to rule on school board eligibility, although that's eligibility to be a member of a county board of education, but that's a little bit limited. We can only decide or determine whether another position that they hold constitutes a public office or not. We also can give advice about West Virginia Code 61-10-15 and give exemptions from that or contract exemptions from that particular provision. We handle the Administrative Law Judge Code of Conduct. That's different from the Judicial Investigation Commission that handles the Code of Conduct for circuit court judges and magistrates and so forth. We're talking about here about administrative law judges for the grievance board or the employment security or something along those lines. We also handle lobbyist registration, financial disclosure statements, and we give interpretations of the Open Meetings Act, although we do not handle claims met. Those violations of the Open Meeting Act, those go to circuit court. Okay, private gain. Basically, that's the principle upon which most of the Ethics Act is based, essentially. And it basically, at the very get-go, indicates that a public employee or a public official may not use public resources, including all the things you'd think, time, supplies, the premises, subordinate staff, and so forth, for private gain of themselves or for another. And now, of course, there's an exception for de minimis use or gain for personal purposes. In other words, if you accidentally carry the pen that's purchased by your agency home with you, that would be considered de minimis. Couple of things, though, that catch up a lot of people, and that is public resources would include bonus points that the agency acquires from making purchases for office supplies, computers, things of that nature. There's an exception to that general rule for business travel-related bonus points, such as reward points for airlines, hotel, and gasoline, things of that nature. That exception is made not by us, but by the legislature. They specifically exempted those type of reward programs from the general requirement that those all belong to the public agency. Here's a tricky one. An agency may not allow its employees to use, or at least no more than a minimal amount, their agency-provided cell phones as for personal purposes unless the employees pay a reasonable fee to the agency. And this is true even if the agency has an unlimited data use plan, so that it doesn't really cost the agency any more to do that. And even if if the employee pays a reasonable fee to the agency for using the business provided cell phone for personal purposes, there's still a requirement that they not use it for commercial purposes or for political campaign purposes. Next topic, nepotism, a popular one. And I'm having difficulty getting my slide to work. I do not know why that is the case. Perhaps it will go on here. All right. Nothing like a technical difficulty. In any event, the nepotism rules, first thing that I should mention to you, the definition of relative that's contained in the West Virginia Ethics Act. It's not what we West Virginians would normally consider to be relatives. It means, as indicated there on your screen, spouse, mother, father, sister, brother, son or daughter, grandmother, grandfather, grandchild, so forth. It does not include cousins, first or second, or it doesn't include uncles, anything of that nature. The rules are fairly simple. A public official or a public employee may not directly supervise relatives, nor may they be involved in decisions affecting them. That's it, essentially. The nepotism prohibitions don't really prevent relatives from working together. And I'll use an example of that. May a prosecutor employ individuals who happen to be married to each other as assistant prosecutors? Answer is yes, as long as the Act's nepotism provisions and applicable legislative rules are followed. And in the case of assistant prosecutors, they do not supervise each other. They're supervised by the prosecutor, and just because they're assistant prosecutors doesn't give them any control over the terms and working conditions of their spouse. Next topic is unauthorized spending, and that is when an agency spends money for something it's not supposed to or not allowed to. Now, the Ethics Commission has kind of limited involvement in determining what is unauthorized spending. We rely upon what the West Virginia Code provides, the legislative rules, Attorney General opinions, and things of that nature to determine whether an agency can spend money on particular subjects. And you might ask, well, then why is that authorized spending a concern for the Ethics Commission? Well, the Ethics Commission has held that spending money or public resources on an unauthorized purpose or for an unauthorized purpose constitutes private gain. Further, the Ethics Act, as we've indicated earlier, prohibits the use of a public officer employment for the benefit of the official or employee, but also for another private individual. The Ethics Act also indicates, though, that a public official or public employee is not violating the private gain provision if they're performing their usual and customary duties without any additional compensation. And when we're looking at a situation, whether an action is authorized or not often provides kind of the tipping point or the most important factor when determining whether a public official or public employee is doing something for private gain of another or whether they're just following their usual and customary duties. Some things are obvious about what unauthorized spending do. For example, rewarding a mayor with a trip to Myrtle Beach or using public funds to support a candidate in public office. But there are other situations where it's not quite so obvious. The big question we get frequently is, may public funds or resources be used for flowers for a funeral of a deceased employee or official? Well, no, that's unless specifically authorized by statute. And I've not seen that anywhere for any public agency that I'm aware of. Basically, it can't be done. Those public resources can't be used. There are some tricky exceptions. For example, if rather than sending flowers to the funeral of a deceased public official, the public governmental entity puts up a big wreath at the city hall or a big wreath at the county courthouse or something of that nature, That's generally considered a public display as opposed to, flowers being sent to the gravesite or to the funeral home or something of that nature. Secondly, may public funds be used to pay for public employees or officials to attend a seminar or conference? Well, yes, if it's authorized by statute or if there is an overriding public good. In other words, if this conference or this seminar will make the public official or the public employee better at their job, in which case the benefit to the public is the predominating factor. We're often asked about employee recognition and retirement events. Is that something that's authorized? Well, the Ethics Act, or the Ethics Commission, I should say, has interpreted the Ethics Act to allow a limited amount of public resources to be used for these employee recognition and retirement events. They can be used for food, beverage, entertainment, and gifts or mementos, I guess, like a watch or a plaque or something of that nature. There are limits on it. The total amount of public funds per agency that can be used is $25 per employee per year. In other words, if you have 100 employees, then $2,500 is the maximum you can use, and you cannot use more than $100 per a particular employee. And what that means is the $25 per all the employees for each employee gives you the amount or the funds that you can use that year, but you can't, you don't have to divide it equally among your employees, but you can't obviously go over spending more than $100 on a particular employee. And we're talking about public resources here too. If the employees themselves or the public official want to dig into their own private resources, they can spend any amount they feel comfortable with for these type of events from their private resources. We're talking about public resources, the budget of the agency. Now, endorsements. Obviously, most people recognize that if you're a public official, you can't go on a commercial and say that Tudor's Biscuit World makes the best food in the world and you ought to go there or something like that. But that's obvious. But there are some trickier areas where you have to be careful as a public employee or a public official. For example, you cannot endorse commercial products. And that would include testimonials such as saying that you're a satisfied customer or filling out a survey from the company indicating essentially that you value their service and things of that nature. When you work for or run a public agency, you just have to not fill out those type of surveys, to ignore them or just send I can't do it. Along those same lines, we had a question a few years ago here from a college professor who asked if he could invite a candidate to speak at one of his political science classes, and the Ethics Commission indicated that he could, but he had to give an opportunity to other candidates in that same political race to come and speak at it before his college class. And that's the idea behind that is if he just invites one and brings them in, that's akin to an endorsement. Same thing with wearing T-shirts, cups, and things of that nature with political slogans on them. Like again, about 4 years ago, the Ethics Commission addressed a question where a town employee brought a cup which had a political slogan on it, and they brought it in. It was personal. There was a question about whether they could use that at work, and the response of the Ethics Commission was, yes, they can, but they can't use it in a place where the public might observe it. In other words, if they're at the front desk, they have to keep the coffee cup turned away so that no one can see what it says. Disclosure of confidential information. Now, this is kind of an outlier or an exception. Most of the time, anything you do has to, in order to be a violation of the Ethics Act, it has to be for the private benefit of yourself or someone else, usually a family member or something. Confidential information, though, may not be disclosed even if you or no one is getting any benefit out of it. It's just simply something that's forbidden. And it's also one of the several violations within the West Virginia Ethics Act that constitutes a criminal misdemeanor as well. So not only can you have a complaint filed against you for that, but you could also be prosecuted for it and by the prosecuting attorney. Let's talk about gifts. The little meme we've put up there, no gifts, is a little bit misleading. That's not quite true. The prohibition is against gifts of over $25 from interested persons. And who would be an interested person? Well, obviously a lobbyist, one of them up the legislator. It could include somebody who was trying to sway the city council or the county commission. It would also include someone who seeks or does business with the public servants agency. It could be someone who is regulated or controlled by the agency, or anyone who has a specific financial interest that's substantially affected by what the public official does. The $25 limit, by the way, is in our regulations, and that's based on the thought that anything below $25 is really de minimis or not particularly relevant. Now, there are some exceptions to the gift rules. Meals and beverages of any value may be given to a public official as long as the person who is purchasing the meals and the beverages is present for the meal and I guess consuming the beverages too, which means basically someone who falls into this area of interested persons can't give you a gift certificate for $50 to go to a restaurant. However, they can take you to that restaurant and eat the meal with you and pay for it. The other exception is ceremonial gifts with insignificant value. And we're talking about things like plaques, trophies, things of that nature. When we say insignificant value, we're talking about what they are worth on the market, more or less. Any of you who've been involved purchasing trophies and other knickknacks like that know that those can be quite expensive, but we're talking about their value. And though a fancy dancy trophy might cost $100, it isn't worth $100. And finally, there's an exception for gifts of purely private in nature. And what that refers to, for example, let's assume that you're a lobbyist and your mother is in the legislature, and you always get your mother a gift at Christmas time. Those type of gifts, an old classmate that you've exchanged gifts with for years, things of that nature are permitted. Those are not considered, and the $25 limit does not really apply to them. The gift rules also, in addition to what you can accept, also relate to whether or not you can solicit or ask for gifts. And generally, that's prohibited. There is an exception, and that exception is contained in the statute, which is cited up there at the top of the slide. And that's the solicitation of gifts for charitable causes which do not involve any pecuniary benefits to the agency's public officials or employees. That is permitted. What is a charitable purpose? Well, generally, the Ethics Commission has defined a charitable purpose as one that benefits the poor or disadvantaged or promotes the public good. There's an important reminder here, and this really applies to most of the things I'm talking about today, and that is the public agency may impose stricter standards than what the Ethics Commission and the West Virginia Ethics Act imposes. What the Ethics Act does is provide a floor. Basically, you have to be that resistant. In other words, you have to meet those minimal standards. The public agency can then make more strict ones. They can say, for example, we don't care whether it's for a charitable purpose or not. You cannot use your office or use your public employment to solicit donations for it. An example of something that really, I guess, isn't so much of a charitable cause in the traditional sense, but does involve the charitable cause in our definition. That is things that are for the public good, occurred in Advisory Opinion 2021-02. And that a mayor asked if he could appear in a video using his name in public office to promote or more or less endorse and solicit donations for a local nonprofit drug and alcohol recovery center. That was held to be okay because it is a cause for that, enhances the public good, and it wasn't for a commercial business. Rules for solicitation for charitable purposes. Even if the purpose that with which you're seeking gifts or to solicit donations is valid, there are still certain things you have to do. Those are found in our regulations. I've just put some of the more salient points up here. That is, you can't know face-to-face or oral solicitations. It needs to be in writing. It needs to be a general solicitation. You can't target people who are do business with your public entity or people who are trying to do business with them, and you have to make it very clear that all donations are voluntary and that you won't be punished for failing to donate, and you will not be rewarded for donating. In other words, there's no quid pro quo. An example of that. The city had asked if they could raise money to support a free outdoor concert series in its amphitheater. The Ethics Commission indicated that was fine, but they suggested that they use anonymous sources for soliciting donations like the GoFundMe or other similar crowdsourced fundings. And they indicated that the general rules apply. In other words, no face-to-face solicitation, no soliciting of subordinates, things of that nature. Public official name or likeness. In general, public officials or agents or anyone on the public payroll can't use the official's name or likeness on trinkets that are paid for by public funds, nor use public resources or funds to distribute, disseminate, publish, or display the public official's name or likeness for the purpose of advertising it to the public. I've got a little example there. One thing I want to stress here, basically, this rule applies, in and out of season. In other words, it doesn't have to be near the election time when the public officials are wanting to get their name out. It doesn't have to, it can be for something that's not clearly a political source or, a political purpose. If you're using public resources, you really have to limit, though, whether you paste the face of the public official there or his name or anything of that nature. And it's kind of one of those no-fault things. Basically, if you do it, whether your intentions are good or not, it can still be a violation of the Ethics Act. Well, there are some exceptions, which you can, pretty much guess. Basically, name, image, or likeness can be used in the things that's used in the normal course of business, like on letterheads, envelopes, educational materials, office signs, things of that, press releases, things of that nature. Those are exempted, basically. Now let's talk about prohibited contracts and some exceptions that are allowed. Public officials and public employees may not have a financial interest in a public contract. In other words, a contract with the agency or the governmental entity over which they serve as an official or work as an employee, if the particular contract in question is under their direct authority or control. We need to talk a little bit about that and give some examples of what authority means and what control. They're not identical in the West Virginia Ethics Act. For example, a city paving contract is clearly under the direct authority of the mayor and the city council, who have to vote to put it out for bids and have to vote whether to accept the contract and pay it and make the contract or execute it. Control is a little more touchy-feely. Control over an agency's decision to enter into a contract doesn't mean you have the last word, that you're the one who approves it at the end. If you were the one who brought up the need for this contract or to purchase this matter or this service, if you have close involvement, not the ultimate decision, but close involvement with that ultimate decision, or if you supervise or have oversight over the contract when it's performed. An example of this, I think, was related to a prosecuting attorney. There was a contract for office furniture and things of that nature, office machines in his office, and he or the company that he had could not bid upon that contract because even though the county commission voted whether to buy it or not, and the money came from them, because he was the one who was running the office where the office machines and office supplies and things of that nature were used, he was considered to be too involved and have control over the contract. Now, this is one you could have knocked me over a feather when I started working for the Ethics Commission. City officials may actually work for a city. Now, that is a contract, and as a city official, they would have, authority or control over who gets hired. They may do so. However, they have to recuse themselves from the bidding process, the process of determining who's hired. And after if they become an employee essentially of the city for which they're the mayor or one of the city councilmen, they have to recuse themselves from votes about the terms and conditions of their employment. That's pretty sensible, though, I guess. Now, the Ethics Commission has discretion to grant an exemption to public entities based upon undue hardship or excessive cost. For example, if the county commission wants to purchase a service and the only person who provides that service is one of the county commissioners who owns a business, and there's no other business where they can get this service, or the other places they can get this service that would be double the cost or something like that, they can, the public entity itself can request of the West Virginia Ethics Commission a contract exemption, which would permit them to contract with one of their members, basically. And but that we look at those very, very carefully. And like I say, it really has to be a case of hardship or excessive cost. It can't be just something where you ask for it and it's automatically granted. Voting. This is another important area, and I would say probably close to 50% of our calls come from people who are involved in that situation and want to know, do I have a conflict of interest? Is this matter that's going to be coming before the city council or the county commission or one of these other bodies? Is it something that I can hear and vote on? Okay. The general voting rules say that a public official may not vote for something that relates to which he or an immediate family member or a business with which he or an immediate family member is associated has a financial interest. They may not also vote on personnel matters that involve a relative. There are some exceptions to that. For example, if your relative is a member of a class of 5 or more, in other words, if your relative works for the sewage department of the city, and that the city employs 25 people in the sewage department, and you've got a relative who's one of them, that would be considered the class exception. That's a situation where it would only affect that person in the same manner it would the other 24 people in the department. You would be able to vote. Now, this is something else that's important. If you are required to recuse, if you have a conflict of interest that requires you to recuse yourself from discussion of a matter or vote on it, it's not enough to simply keep silent or to abstain. If you have to recuse yourself from the discussion of a contract or something of that nature, you must disclose your interest at the meeting. You must leave the room during both the discussion of and the vote on the issue, and you must instruct the secretary to the person who's keeping the minutes to reflect your recusal and the reason for your recusal in the minutes for that particular meeting. Employment restrictions. A full-time public employee and this only applies to full-time public employees, may not seek employment with or do business with, buy, sell, lease, things that matter, with any company or person with which he or she or one of his or her subordinates took some sort of regulatory action in the previous 12 months, or anyone who currently has a matter before his agency upon which he or she or one of his or her subordinates is working. They also can't seek work or do business with a vendor over which they exercise control. Again, they or one of their subordinates. There are public exemptions available. In other words, if you are thinking about leaving public service, either as an employer or an official, but can't afford to do without a paycheck, so you need to hunt for a job before you leave your past one. And these people who you have taken regulatory action over, or who are vendors, are really the only people that you have expertise to go to work for. You can seek from the West Virginia Ethics Commission an employment exemption, which will allow you to seek another job, basically, before you leave your public job. But it's very transparent to you. Your supervisor has to know about it. The Ethics Commission has to know about it. So it's all above board. Similar restrictions apply to people who are moonlighting, people who are working, in addition to holding the job as a public employee, are also working for somebody else in the evenings or on weekends. We have it was new, I guess, at one time when I worked on this slide. It's been out for about a year now. A pamphlet on that called Second Jobs in the West Virginia Ethics Act that goes over the various factors. And again, if it's a situation where you're not sure whether this second job would be a violation or could fall within one of these employment restrictions, you can always give us a call or hit us with an email, and we'll try to help you figure it out. Question comes up: what is a matter before my agency? In other words, that is one of the key elements in figuring out whether I'm restricted from applying for a job with these people. Well, the commission has addressed that on several occasions. In most cases, it's best to just contact us and give us the particulars and let us try to help you dope it out. But in any event, in Advisory Opinion 2023-06, a state agency director was able to continue his part-time of-counsel attorney job with a private law firm, so long as the law firm did not represent clients before state agency. If they did, then they would be involved or have a matter before his state agency, and obviously would be before him or one of his subordinates, or his or her subordinates, I should say. Same thing, a state employee may work for an engineering firm that had clients subject to the public agency's control, but did not do work in the area where the employee or the employee subordinates actually controlled. In other words, they were over-regulating the businesses of this type in a particular geographic area, and this firm that he was working, or he or she was working for, or wanted to go to work for, didn't do any work in that area. In other words, nothing that they dealt with would ever come before him or one of his associates, or subordinates, I should say. Vendors. Basically, full-time public employees may not work for a vendor. Again, if they or a subordinate has authority to enter, to deal with the contracts with these vendors, or exercises authority or control over the public contract. And the statute goes into some details. You can see what relates to having control over the vendor's contract, as opposed to just exercising authority about whether to approve it or not. Some of them make sense, some of them don't, but essentially that's what the law requires. And when I say they don't make sense, they don't make sense to me. I don't understand why some of them are in there, but we are required to apply those, and we will, of course. Representation. A public employee may not represent a private party in a matter even after he leaves public employment if he or she had worked on that particular matter involving that specific party before they left public service, or if they personally or substantially participated on behalf of the agency in the decision-making process. Now, of course, the agency itself can consent and say, that's fine, you can come in and represent these people in this matter. If they do, it's okay, but without their consent, you simply can't do it. Revolving door. What this applies to only a limited amount of public servants and public employees. If you're an elected or appointed public official or a full-time staff attorney or accountant, I'm a full-time staff attorney, so this would apply to me. You are not able to appear before your agency, even after you leave work for that agency, for at least 1 year after the separation. In any contested matter in support or oppose a particular proposed rule, support or oppose issuance of a license or permit, rate-making proceedings, and anything that relates to the expenditure of public funds. Financial disclosure statements. Certain public officials must file a financial disclosure statement by February 1st annually. Here is a list of the individuals that are required to file that. There are actually, I think there are a couple of cities, I believe, that require that their city council men or women and their mayor to file those. Not very many, though. But for the most part, they're county elected officials and elected state officials and high-ranking members of state agencies, as well as people who are on state boards or commissions who are appointed by the governor. Again, if you have any question about whether or not that you should required to file a financial disclosure statement, give us a call. In this case, if you call me, I will pass you along to Ellen or Caitlin or Rachel, who will be able to help you. But we're always willing to help people to try to figure out. We don't want people to do something they don't have to, but we don't want them to mess up and not file something that's required. Sanctions. There are a variety of sanctions that apply to people who violate the Ethics Act. In other words, if someone does something wrong and someone files a complaint against them and we investigate it and decide that they did violate the Ethics Act, there are a range of things that can be done by the West Virginia Ethics Commission to penalize those people. Public reprimand can be issued. They can require them to restore the public resources that they took or used or that they shouldn't have, to make restitution to their agency. People can be fined up to $5,000 per violation. They can be required to reimburse the commission for the cost of the investigation. And we can, or I say we, I mean the Ethics Commission, not me, can recommend that the individual be terminated from employment or removed from office. Now, we cannot actually do that. We cannot order the county commission to fire someone or remove them from office, but we can recommend it. Now we move to another area, the second area, basically. It won't take quite as long, and that's the Open Meetings Act. I want to make it clear, I think I've already said this once, but I just want to make certain I get it across. The West Virginia Ethics Commission does have the authority to render opinions about how the Open Meetings Act applies and to give advice. But if there is a question of a violation of the Open Meetings Act, you can't file a complaint with us like you can with a violation of the West Virginia Ethics Act. If there's a violation of the Open Meetings Act, it has to go to circuit court, the circuit court where the agency or the governmental entity is located. Now, we're going to talk about a number of things. Basically, the big one is what meetings are subject to the Open Meeting Act, what kind of meetings are not. We'll want to talk a little bit about notice agenda and executive sessions and the requirements for meeting minutes, basically. Now, what's subject? It's pretty wide. State, county, municipal, administrative, and legislative body, or any body that meets the definition of public agency, which means county commissions, obviously, it means city council, and a variety of other committees or commissions or boards that meet and help rule or govern a particular agency. Again, if there's a question about whether it applies to your group or not, give us a call. A meeting which is subject to the OMA occurs when a quorum of a governing body meets on a matter for which a quorum is required in order to make or deliberate toward a decision requiring official action. I know in my previous existence, I worked for public employees who worked for county boards of education, and we used to invite board members to our Christmas parties and things of that nature, and they'd say, well, we all can't come because then there would be a quorum. It wasn't really true. Essentially, a meeting is only one that requires all the requirements of an Open Meeting Act if a quorum is there and they're there for a matter, on which quorum is required, which is basically to deliberate toward an official action and to take official action. As you'll see in our next slide here, there are a number of meetings that are not subject to where people get together that are not subject to the Open Meeting Act, and the various requirements do not apply. For example, members of a governing body can get together and discuss logistical matters like creating or deciding what to put on the agenda for the next meeting, or if they're adjudicating a matter like there's a question of suspension of a license for an individual or some sort of disciplinary action against an employee. They can also do things like go on site to inspect things, like if they're building a new building, they can go as a group and look at it, just as long as they don't deliberate or take any official action, as long as they're just inspecting it. There are other exceptions, like, for example, if they're just going to listen to someone giving a presentation concerning, I don't know, a new project they have or something like that, as long as they don't deliberate, talk among themselves about what they need to do with that information, as long as they're just receiving the information. Further, gatherings at social occasions like football games or parties or something where a quorum of the governing body happens to be present isn't subject to OMA. When there's no intent to conduct public business, no intent to any kind of discussion to lead later on to official action, then there's no reason for that meeting to fall under the requirements of the Open Meetings Act. Now, the Open Meetings Act, we get questions like this. A lot of governing bodies met on Facebook Live or on a platform like Google Meet, like we're meeting, or Teams or something like that. And that happened a lot during the COVID crisis here a few years ago. And people a lot of times will ask us, is that still in effect? Can we still do that? Well, that's correct. Even before 2020, basically the Ethics Commission has determined that the key is giving the public access to the meeting. And that means there's no requirement of an in-person meeting or a physical space being made available to the citizens, as long as they're given access to the meeting by telephone conferencing or some other electronic means, like Facebook Live or Google Meet or something along those lines. That had been determined even before 2020, and it is still in effect. Now, what are some of the requirements if you have a meeting that the Open Meetings Act applies to, clearly does? Well, first off, you must give notice to the public of the date, time, and place of the meeting, including any committee meeting. Now, how much notice is required? The statute indicates that governing bodies, in other words, county commissions, city council, things that should promulgate their own rules. However, the commission has indicated that regular meeting notice and providing of an agenda for the public to see must be done at least 3 business days in advance for a regular meeting. For a special meeting, it has to be at least 2 days in advance. I would mention that there's a separate provisions in the law for state agencies, and they actually have to give 5 days notice and put it on the Secretary of State's webpage at the appropriate place. With regard to county commission, city council, county boards of education, other bodies like that, Notice has to be, it's sufficient if they post notice, and that tells me I should turn off my phone or put on a no disturb. In any event, if the notice is posted in a public place at the chief building where the entity operates. In other words, if it's a city council, it would be the city hall. If it's a county commission, it would be the courthouse. Posting notice there in a public place is sufficient. As of now, the Open Meeting Act does not require you to publish it in a newspaper under legal notice, or that you provide advance information to the media, or that you put it on your website. That's not required by the Open Meetings Act, basically. If you just publish it or post it before the requisite time in the public place. I mean, I notice many boards of education, for example, will post those on the door at the board office so that people can see it even if the board office is closed. And that's a good idea. Now, here is basically from the Ethics Commission's website, an example of how, if you're going to have regular meetings and you've already got the date set, what is sufficient in order to give notice to people. In other words, if you're going to meet the first Wednesday of every month, basically, sometimes it's sufficient to basically provide that notice at the very get-go that we're going to be meeting on these dates. Now, that you still do 3 days before the meeting, provide the agenda, post it basically so people will know what's going on. Now, emergency meetings. Emergency meetings are a little different. If there is an emergency that requires basically the board to meet, or the commission to meet at an irregular time, or to meet, basically almost immediately, they may do so. And the requirements for notice require that they give as much notice as is practicable. But an emergency meeting can only be done for a real emergency, where there's an unexpected event which requires immediate attention. It's something that creates a threat to public health and safety, and an imminent threat of damage to the property. And it's something that might result in a material financial loss or substantial harm to the public agency, things of that nature. Again, essentially, if you have any doubt as to whether a special meeting you're calling would qualify as an emergency meeting, we certainly are glad to speak with anyone who wants to talk about it, and we'll try to advise you as to whether it would qualify or not. Now, I mentioned agenda. Each governing body, in order to make notice that we're going to have a meeting meaningful to the public, they have to provide them with an agenda too, so that the public will know what they're going to talk about or what they're going to discuss at this meeting. As a consequence of that, they do have to provide an agenda, and they have to provide it for a regular meeting at least 3 days ahead of the meeting, basically. And they have to stick to that agenda. In other words, they can't take up issues that are not on the agenda. If something comes up at the last minute, you have to call an emergency meeting, so be it. But the best practice is do that, or specifically to just hold the item over for the next meeting and put it on the agenda for that meeting. How specific must an agenda be? Well, you don't have to put down a blueprint of everything that's going to happen, but it must be specific enough for the public to understand or what's going to happen or what's going to be discussed. In other words, you can't just put down old business, new business, personnel, or something along those lines. You need to be a little more specific. For example, instead of personnel, you could indicate that you're going to fill the position of office manager, or as opposed to new business or old business, you can put down, we're going to open sealed bids for a project that we've put out for bids, basically. Like I say, the key is to make it specific enough that the public will know what's going to happen and what's going to be discussed, so that they can be there if they want to. Now, there is a section of the law which we, and by we again, I mean the Ethics Commission, do not have any authority or even any ability to give any kind of opinions or to address, called the Uniform Public Meetings During Emergencies Act 2023. That basically talks more about what kind of emergency will justify meetings, and how the meetings are to be conducted during that time. Excuse me, folks. In any event, that's something that we can't really address. It is out there, though, and certainly in the case of an emergency like the coronavirus, it might be helpful to know what the requirements are. Now, one of the biggest questions we get is, can we go into executive session to discuss a particular matter? Well, the statute says that you may only go into executive session for reasons that are permitted or listed in the act. And there are approximately 12 of them. Not all of them are applicable to every situation, but the major ones, for example, would be basically personnel is, I think, one of the more popular ones. In any event, when you think you're going to have an executive session, you really shouldn't put down in the agenda that this is a set fact that we are going into executive session, because executive sessions require a motion and an affirmative vote of the members of the body, public body, in order to go into executive session. And you can't know ahead of time for sure that's going to happen. Now, you can put in the agenda that we suspect or it's anticipated we'll go into executive session to discuss this matter. That's okay, but you can't just put down there will be an executive session. Now, I think we need to go in and talk a little bit about what kind of things you may go into executive session to discuss. Now, I might mention there the discussion for these items could be in executive session. When it comes time to make a motion and a vote, that has to be taken in open meeting. In other words, you can go into executive session to discuss personnel matters, but if you are going to vote to hire someone, the motion to hire them and the vote to approve their hiring has to be done in open session. There are other things, like things involving commercial competition. If you're putting out a bid for some item, you may want to discuss basically what you will accept and what you're looking for, and so forth. Things that would give somebody else or give your vendors a commercial edge over the public entity if they knew what the city or the county was willing to pay. Things of that nature can be discussed in executive session. You can discuss things that matters which relate to state statutes and things of that nature. You can go into executive session when it comes to disciplining or suspension or expulsion of a student or of a public employee. There is a proviso, though, that if the student or the public employee, it says, I want my disciplinary proceeding to be an open session, then you have to do that. There's another one, situation, which we didn't put up there, but it's an important one. If the public body wants to consult with their attorney, if it is a matter which is covered by the attorney-client privilege, then our court system, as well as the Ethics Commission, has said that you can go into executive session to meet with your attorney to discuss confidential matters. Like I say, in fact, I think there's a case that's headed to ICA or Circuit or Supreme Court now on that issue. I haven't heard anything about the decision coming out yet, but that may change. But as of now, attorney-client privilege does justify a governing body to meet in executive session with their attorney to discuss these types of matters. Now, one thing the commission has ruled pretty uniformly on, that is that when you have a discussion in executive session, that the matters that are discussed aren't automatically confidential. What we're saying there is, if you go into an executive session and you discuss a matter, and then one of your members comes out and talks to everybody and about what's happening, that isn't necessarily wrong. The matter has to be confidential for some other reason other than it was discussed in executive session. For example, if it's something like information concerning a student, if you're a school board, or any public body discussing the medical information about one of their employees or something like that, that would remain confidential. But if they just go into executive session, or if you're just in executive session talking about any other matter, there's nothing to prohibit one of your members from talking to other people about it. Some boards and groups, I think, have tried to set up policies where anything they discuss in executive session is considered confidential. That might work if everybody agreed, but it's something you need to be careful about. Minutes. And we're getting close to the end here, folks, but the minutes for a meeting can be, have to have certain things, and that's, as indicated there on the slide, the names of the governing member bodies or members of the governing body who are present, any motion or proposal, anything that's taken, votes taken on, and who voted and what the final decision was. All of those have to be in the minutes. Minutes can be a little more explanatory than that, and there's nothing wrong with that, but it's not a requirement of the OMA. Here's an example from of the minutes that were put up by the Open Meetings Subcommittee of the Ethics Commission, basically, and gives you an example that you can look at. These minutes must be made available to the public within a reasonable time, and the commission has determined a reasonable time is 1 day after the next meeting. In other words, you have a meeting on day 1, then another meeting on day 8, where you approve the minutes from the meeting on day 1. Then on day 9, those minutes should be available to the public. Standing. A member of a public body that is governed by the Open Meeting Act may ask for a formal advisory opinion, but members of the public or people who are not on that particular public body cannot ask it on their behalf. And now, what are the sanctions? Again, as I mentioned a little while ago, you have to go to circuit court to get sanctions for violations of the Open Meetings Act, but it could be a misdemeanor, criminal misdemeanor. It could be, you could be fined. You could be liable for court costs, and the court may decide to annul the vote taken at a meeting in which the act was violated. Now, here is our information, basically, to contact us, the phone number, as well as our website and email. I'm going to stay on this meeting and keep it open for another 10 minutes or so in case anybody wants to stay and ask a question. We would hope that all of you would take our survey. I put it in our chat room, and it should be available to you there if you want to go and download it and fill it out. All you need to do is fill it out, and it'll automatically send your answers to us, essentially. I wouldn't mention, as I believe I indicated before, some of you were here. If you are required to attend this training by executive order or for some other reason, and you want to make sure that you are given credit for being here, we do keep track of the people that join, but we just have their email addresses or phone numbers. And if you use somebody else's iPad or something like that to get on and view the training, basically, and you want credit, you can just email us and say, I attended your training and I want you to keep a note, a record of that, and we will honor your word. So just send us an email saying, I want to make sure you get the fact that I was here today. In any event, that's all I have. I'm going to go ahead and cut the presentation off, but I'm going to stay on the meeting for another 10 or 15 minutes. And if you wish to ask a question, just basically unmute yourself and ask the question, and I'll do my best to answer it. Well, thanks for the thumbs up. Anybody has a question, feel free. And as I said, if you're not comfortable Speaking with everybody here, well, people are dropping out like flies now, so there soon won't be very many people here. You can always give me a call or hit me with an email later on, and we can discuss it individually. As I say, though, I'm going to stick around here till about 1:10, just in case.